Statistics have shown that funding from the federal government.
On Law Weekly today, we revisit what the heads of courts are saying about the judiciary, and then we talk to a senior advocate of Nigeria, Kunle Ogunba, to get his perspective about the challenges of the legal system and much more. Welcome to Law Weekly on Channels Television. I am Shola Shele. Before we get into our lineup for today, let's quickly do a recap of the top legal stories in the news.
We begin at the Lagos High Court Ikeja, which struck out a suit brought by Alhaji Kawu Baraje's faction of People's Democratic Party against Alhaji Babanga Tugo's faction for lack of jurisdiction. The Baraje faction had asked the court to stop Alhaji Babanga Tugo's faction from parading themselves as national officers of the party. Ruling on a preliminary objection filed by the Tuko faction, which challenged a part of the court to hear the case, Justice Oludotun Adefokpe Okoje held that the Lagos High Court indeed has no jurisdiction to adjudicate on a matter which emanated outside its territory. Justice Adefokpe Okoje also said the cases originated within the Federal Capital Territory and must be heard by the courts within its territories. Staying in Lagos, a federal high court last week freed 15 Russians and their ship MV Mar Sea Diver, who were accused of smuggling charges preferred against them by the federal government. A court presided over by Justice James Soho discharged the Russians following a withdrawal of charges against them by the federal government. No reason was given for the government's decision by its counsel, Mrs. Ajara Yusuf. But Director of Public Prosecutions in the Federal Ministry of Justice, Mrs. Olufemi Fatunde, had on April 30 told the court that some of the Russians were wrongly charged, adding that the prosecution was going to amend the charges. After Justice Soho discharged the Russians on Tuesday, Yusuf immediately substituted the former charges dated June 18, 2013 with another one dated October 7, 2013, reflecting only the names of Blue Seas Company and Chinenye as the accused persons. Justice Soho has fixed November 26 for the arraignment of the two accused. A federal high court in Abuja has fixed Monday, November 7 for judgment in the trial of Kabiru Umar, aka Kabiru Sokoto, who was charged with complicity in the 2011 Christmas Day bombing at St. Teresa's Catholic Church, Madala, Niger State. About 40 worshippers died in that incident. Justice Ademola Adeni chose the date for judgment on Monday after parties adopted their final written addresses. Lead prosecution counsel Chioma Onuebu urged the court to ignore the defendant's argument and uphold the evidence and submissions of the prosecution in convicting the accused, as the prosecution has proved its case beyond reasonable doubt and the guilt of the accused has been established through his confessional statement, circumstantial evidence, and eyewitness account. Defense lawyer Sheriff Oko argued that the charges against the accused are not based on evidence and such should be discountenanced. Oko contended that before a person could be declared guilty under Section 7, Subsection 1 of the Terrorism Prevention Act, his actual knowledge of the crime must be proved. According to him, Boko Haram was not an illegal body until around April this year, when the federal government proscribed and labeled it so. And on the foreign scene, a court in Pakistan on Friday ordered former military ruler Pervez Musharraf to be held for 14 days over a 2007 raid on a militant mosque in Islamabad. Pervez Musharraf was arrested on Thursday, a day after a court bailed him in the last major case against him, raising the possibility he could leave the country. Pakistan Supreme Court on Wednesday granted Musharraf bail over the death of a rebel leader. He had already been granted bail in two other major cases against him, including one relating to the assassination of former Prime Minister Benazir Bhutto. And away from the courts, the people of Bakassi are still subject to inequality, subjugation, and harrowing treatment. There are presently over 3,000 internally displaced persons living in camps in very unconducive conditions. These were some of the facts revealed at this lecture, which focused on the need to review the plight of the Bakassi people and protect their fundamental human rights. It's a lecture in honor of the retired Justice of the Federal High Court, Justice Charles Achibong, and it attracted eminent judges, lawyers and politicians, and some people of the Bakassi region.
I'm advocating that the federal government, even though we missed the chance recently, because I listened to the speech of the president, when he addressed the United Nations General Assembly, the 68th session of the General Assembly. I thought he would have used the opportunity to escalate and inform the world about the plight of the people of Bakassi.
That suggestion generated varied interesting reactions, one of which is that of the former governor of Cross River State, Donald Duke, who said the judgment was largely political.
Because we actually thought, look, if we have 2/3 of this, why not just share this? Let Cameroon keep 1/3 and we keep 2/3. But we had a legal team that thought it was okay. We also had Prince Ajibola, who was, I think was a judge advocate. And he assured us that from the going on behind the scene, we looked good. Then we finally lost. We visited with the British Prime Minister, Tony Blair, and he made it very clear to us that we never stood a chance.
For the celebrant, Justice Charles Achibong, Nigerians can remain proud of its judiciary despite the many issues facing the country.
I think that the Nigerians should have confidence in an institution that is most conscious of its obligations to the country.
The consensus among the participants at this lecture is that the Nigerian government must be genuinely committed to the welfare of all its citizens, including the people of Bakassi.
You see, life has just got easier. You stay connected to Channels TV, where news and innovations are shaping our world. Simply log on to channelstv.com to get the breaking news. Browse the homepage according to what matters to you. Tap on the extended coverage of business, sports, politics, lifestyle, infotech, entertainment, health, world news, and lots more. Click on the live link and see the news in real time. Do you want to watch the latest video of the day? It's just a click away. Friend us on Facebook, YouTube, follow us on Twitter, Google+, participate in Channels TV poll and share your comments. It's a website you can talk to. Your voice will be heard.
ChannelsTV.com. The news at your fingertips.
Welcome back. Let me take you back to the legal year ceremonies which marked the commencement of the new legal year and some of the key things the heads of the courts talked about that would guarantee a better judiciary going forward. First, we begin with the Chief Justice of Nigeria. Here's how Justice Aloma Mukta lamented the decline in the allocation of funds to the judiciary.
Over the years, funding of the courts has remained a challenge, as evidenced in the conditions of many courts in Nigeria today. Statistics have shown that funding from the federal government has witnessed a steady decline since 2010, from 95 billion in that year to 85 billion naira in 2011, then 75 billion naira in 2012, and dropped again in the 2013 budget to 67 billion naira. Indeed, with this amount, if the amount allocated to the extrajudicial organization within the judiciary is deducted, the courts are left with a paltry sum to operate. The simple implication is that our courts are increasingly finding it difficult to effectively perform their day-to-day constitutional roles. The resultant effect of a slim budget in the judiciary is that a number of courts in Nigeria today evince decay and neglect of infrastructural amenities, particularly at the state level.
The Chief Judge of the Federal High Court, Justice Ibrahim Alta, at the legal year ceremony of his court in Lokoja, the Kogi State capital, talked about inadequate manpower and some of the measures he has put in place with regards to practice direction to guarantee a more robust adjudication.
The Federal High Court and the judges and staff will continue to offer robust adjudication and high-caliber service delivery. In our efforts to ensure that we eliminate delays in the court, I've issued the practice direction with regard to payment of penalties penalty fee for late filing of processing. There is also a criminal procedure to take care of offenses like rape, kidnapping, terrorism, etc.
And now to our interview segment. My guest, Senior Advocate of Nigeria, Kunle Ogunba, speaks the minds of a lot of Nigerians when he identified the delays and the slow pace of justice as the greatest challenge of the Nigerian judicial system. He has some interesting perspectives for tackling the issue. We spoke about that, the agitation for a national conference, and much more. Thank you for talking to us.
Yeah.
You attended some of the conferences to mark the new legal year. At the swearing-in of Senior Advocates of Nigeria at the Supreme Court, the CJN cried out over poor funding and the budget of the judiciary. At Lokoja, the Federal High Court program to swear in the legal year, the Chief Judge of that court talked about inadequate manpower in his court, not having enough judges. He also talked about the practice directions that is issued, to sort out some crimes like terrorism, kidnapping, and all of that. But what do you consider the greatest challenge of the legal practice in Nigeria?
I think the greatest challenge I perceive is that of delay and congestion of courts, which cannot be taken in isolation to the issues raised, inadequate manpower, poor funding, and all that. But I think what they say, justice delayed is justice denied. In 2013, the number of personnel that we have as judicial officers, I don't think can cope with the influx of the population, the increase in commercial activities vis-a-vis the underlying litigation and all such issues. So I think the greatest challenge that we have to surmount is that the cases should be disposed of more expeditiously, and we can do that by getting more personnel, more funding for the judiciary, and then in these days and age, judges too write longhand, and that really is unpardonable, and that in a way contributes significantly to what we call the congestion. If you remove congestion from the our justice administration system, I think by and by we would have succeeded in tackling most of the issues, and when you say the judiciary is the last hope of the common man, then it should be the last hope of the common man in deed and in truth and in practice. You don't file a case where you wait for 10 years for it to be dealt with. Even at Supreme Court now, it takes a minimum of like 4 years, except there are political and other cases, to get your cases even to be mentioned in court. Once you file in 2013, we are looking at 2017 for even the case to come up in court, which is not good. That is even Supreme Court alone, not to talk of the Court of Appeal, not to talk of the High Court. And you go to some courts, you find some judges with 50 cases in a day. It's just one human being, and you don't expect. And then even now, the dilatory system of practice, civil procedure enjoins and encourages the interlocutory applications and interlocutory processes, and not that. And our judges, I even read of a recent case in one of the law reports of a judgment this year, where one of the justices of Supreme Court was complaining bitterly that it took interlocutory processes for a case over 13 years or so to get to Supreme Court, and then he ordered that there should be accelerated hearing of the case when it gets back to the High Court, because the case was remitted to this thing. And then even the investing public, the people in diaspora, those are issues that are germane. If you are an investor, you want to look at the judicial system in the area where you are investing, and to be sure that you are not unduly entangled in any litigation. We have some of the various corporations here, the multinational companies, the GSM companies, some are entangled in litigations, and it's not even good for, apart from socioeconomic well-being. It's not even good for an investment climate. The judges ought to be enabled to be at the optimum.
I recently attended a lecture where retired Justice of the Supreme Court, Justice Adeshola Oguntade, talked about this issue of jurisdiction, which also adds to the problem of congestion and long delays in court, like you have mentioned. And he said one of the solutions that he preferred was that we should do away with this issue of jurisdiction, whereby Federal High Court has jurisdiction over some cases, or the State High Court has jurisdiction over some cases, but we should let judges just take cases. Litigants are interested in justice and their cases being heard, and we should let the courts take the cases and deliver justice timeously and do away with all this issue of this court has jurisdiction or that court has jurisdiction. And he even said he has the advantage of ensuring that all the judges get, expertise on the subject matters that come to them. What do you think about that solution?
I think the point is a moot point, and is for me is unassailable. Even if you look at it from the standpoint of even not the creation of the judges, the courts. If you look at the educational background of each of the judges, it's just perhaps by maybe accident or fate, but that you find yourself sitting, for example, at the Federal High Court as against the State High Court. All of them virtually went through the same regiment in terms of training. So what distinguishes a judge who sits at Lagos High Court from the judge at the Federal High Court? So to me, that strikes at the bottom of the matter and the issue of jurisdiction. And then even if you look at it,
because these issues of jurisdiction also delay the time.
Absolutely, that's what I'm saying, that yes, even in interlocutory processes, the first point that a litigant who is not interested in the matter proceeding timeously is to file an application for challenging the jurisdictional empowerment of the court to adjudicate on the matter. And once the pronouncement is made, he files an application for stay of proceedings and an appeal. So I think rather I will join the view, I will support it, that it is time we have a level playing field. You can choose, depending on the convenience or the issues at stake, to approach it whichever court. The issue of jurisdiction should be, and then even look at it. If we are talking about jurisdiction at the lower court, when it comes to the Court of Appeal, it's the same court that hears all this. There is no specialization. There is no even division within the Court of Appeal to say there's a court of appeal to deal with criminal matters, a Court of Appeal to deal with, all are fused at the Court of Appeal level up to the Supreme Court. So why should there be that distinction at the High Court, at the Federal High Court, and then the State High Court and all that? So I think that the distinction has caused so much damage to judicial development that I think there's time really that it should be taken a look at critically, so that we don't continue to do more damage to the system. Because like I said, the cases are many, and then you have these issues. There's nothing the judge can do in that circumstance.
Still talking about the issue of delay, let's look at lawyers' antics. A lot of people say that some of the things that lawyers get away with here, they won't get away with it in saner climes. You find lawyers bringing applications, jurisdiction, application for this, all invariably aimed at stalling cases and making cases drag on and on and on. What can we do about the antics of lawyers and the tactics they use to stall cases?
Well, basically, you see, I believe that if, for example, we streamline the issue of jurisdiction, and then we have more empowerment, some of these issues, you raise a point to engender a delay if you know that it will take 1 year for it to be resolved. If you raise a point and then it is taken and a pronouncement made on it, in a way, what I'm saying is that if there's no delay in the process, once you raise that issue, sometimes it could be genuine, and sometimes you don't want to throw the baby away with the bathwater. You can discover that some of these issues are raised genuinely. Some have been found worthy at the appellate court that the issues are genuine, but sometimes in an attempt to stifle that interlocutory applications, the genuine litigants might suffer. So for me, the panacea is basically to see that issues are timelessly resolved, more judges are appointed to the bench, and then judges don't write longer, and then we can take one. Even a way to limit this is that some have advocated that interlocutory decisions should not go all the way to the Supreme Court. Maybe it should stop at the Court of Appeal stage, and then we can even enshrine provisions in which interlocutory decisions, appeals over them, is allowed for you to take it at the end of the whole exercise, rather than attempting to use this, as it were, to truncate a speedy trial or hearing of a case.
Still talking about lawyers and their antics, some people feel that what's missing is mentorship, proper mentorship of lawyers. So let's talk about that. When did you take Silk, and did you get any kind of mentorship? Did you get any kind of advice? And what advice would you give to senior lawyers, senior advocates who recently took Silk?
Yeah, we got advice to, in fact, the oath you take when you become a senior advocate prescribes that you advance or advocate the development of the judicial system. You contribute your own quota to the development of the economy and the judicial system in general. So you take that oath. Apart from the mentorship you see from prior senior advocates before you, that oath that you take engenders and enjoins you to do your best to the administration of justice, and you know, as role models as we now become, we sign no show of all eyes, and everybody is watching what a senior advocate would do. So we are expected to live above board and to ensure that we do not bring down the integrity and the repute of the profession.
So this is the advice that you give to the new wigs?
Yeah, absolutely. They should be diligent and more hardworking. For me, really, even when you look at my own background, I didn't set out to say I want to become a senior advocate. I just found out that after so many appearances at the Supreme Court, I found out I was qualified, and I applied for a number of years, 4 years to be precise, before I was made one. Yes.
The federal government has finally yielded to the agitation for a national conference where all Nigerians would sit and talk. But do you think that this is practicable with a functional National Assembly in place?
No, I think even the parameters to set up a conference might even need a conference on its own. Do you get what I'm saying? I don't think we can, a country of like estimated 160 million set of people, that we can sit down and formulate without the attendant rancor and whatever. But to my mind, even if Lord Ligard in those days in 1914 set up a committee to see the viability of a Nigerian project, maybe there would not have been a Nigerian. It was just by a fiat of maybe they say his girlfriend or something who gave a name Nigeria. So there was no prior discussion or agitation towards the margin of the country, as it were. So, but I think the problem we have as a nation is that of leadership. That is where the advocation for the agitation for a conference is so loud at this time. I don't know what it will achieve.
You don't know what it will achieve, meaning you don't subscribe to it?
I do not agree that conference or conferencing or dialoguing, we can dialogue and find a way, but it is not the panacea to the various problems we have.
What is the panacea?
The problem we have is that of leadership, is that of insincerity of purpose of people that we have been privileged to rule us. If there is that pious disposition of our leaders, you will see that the agitation for a conference will dwindle radically. It's because there has not been that leadership. And what we need really is the leadership. We have the constitution where the problem of Nigeria is not even the absence of presence of laws, is the implementation of it, and then the leaders being seen to be true leaders of the people.
So
and
how
you can
do
see
we get the kind of leaders?
it's by it's evolving. It's evolving, and 53 years after independence, I say we are not there yet. But now we've had democracy since 1999, which is a sign that things are, if we can be able to choose our leaders like in other open societies, if we can hold our leaders to be accountable, if there is a leader, there is a malfeasance on the part of a leader when he's in government, and when he leaves, he is made to face the wrath of his wrongdoings, I think we can set a precedent. Our leaders now live as thin gods, and they are not accountable to anybody, and then I think that is the problem. That's the problem. The problem is that of avarice and greed, and once we are able to curtail that, I think we're on the path to development. We should have a society where rigging will not be condoned under any guise. We will have our leaders who emerge truly by a transparent democratic process. It is only then that we can see that we are making the desired progress, in that when you gain power by being seen to be capable, not that some cabal or some clique are supporting you behind the scene, and you are able to retain that post by your performance while in office transparently, and the better candidate wins any democratic duel. Then in that case, we are getting there gradually.
That's the interview segment and the program for today. If you missed any part of it, you can catch it all again by logging into youtube.com/channelsweb. Please leave any comments on our Facebook page. Of course, be sure to like the page and also follow me on Twitter. I'm Shola Sheyeli. Thank you for watching.